Welcome to the third module of the virtual rap sheet workshop. In this module, we will be discussing the employment rights from federal, state, and local laws that serve as anti-discrimination protections for people with conviction histories. The Fair Credit Reporting Act is a federal law that lays out safeguards that protect you from unexpected background checks. Suppose an employer chooses to conduct a background check on you. Know that you have rights. According to federal law, the Fair Credit Reporting Act requires employers to get your written consent before running a background check on you. Note that it is possible for background checks to misidentify you. The Fair Credit Reporting Act also obligates employers to provide you with a copy of your background check for you to review for any inaccurate information. Article 23A is a New York State law that protects you from being unlawfully denied or terminated solely based on a conviction history. Before deciding to deny or terminate employment, employers are by law required to conduct a personalized assessment, which includes a consideration of your conviction history and any positive experiences you've undergone since the date of offense. Most employers violate 23A if they deny or terminate you outright without first considering the following factors. After considering these 8 factors, if the employer can identify a direct relationship between your conviction history and your job duties, or if your hiring would cause an unreasonable risk, the employer can choose to deny you employment due to your conviction history. Ban the Box is a nationwide campaign advocating for the removal of questions about arrests and convictions on applications. In New York State, it is illegal for employers to ask about arrests that did not lead to convictions. To ban the box means eliminating these types of questions in the early stages of the application process and promote fair hiring decisions on the basis of merit and qualification. Some counties in New York State have adopted a form of ban the box laws. New York City passed its own by signing the Fair Chance Act on June 29, 2015. The Fair Chance Act is a New York City specific law that protects you from being asked any questions about your conviction history until a conditional job offer has been made. Employers cannot mention anything related to your conviction history on ads, applications, or interviews until after you receive a conditional job offer. If you see any mention of background checks, arrests, or convictions on a job application, and you have not been given a job offer, call the Legal Action Center. Employers who want to retract a conditional job offer after seeing your background check are required by law to provide you with a copy of the background check as well as a Fair Chance Act notice. In the notice, the employer must explain how they applied the 23A factors to your application for the position. The employer must also hold the position open for 5 days, during which you can challenge errors on the background check and provide additional evidence of rehabilitation. Thank you for joining us in Module 4, Employment Rights. Join us in the next module where we will discuss evidence of rehabilitation.